Vance, I got to go really quickly. What is it?
I can see you guys, but I can't hear anything. And
This is Frank. You should just hear the music playing right now.
Hello.
Did you hear,
Hello?
What?
hear the music?
Oh, okay.
I mean,
I'm gonna use this, I guess. Use what you want. I'll you take one.
Good evening. I'm Hal Geiger. I'm on the board of the Foundation for End of Life Care. And on behalf of the board, I'd like to thank you for joining us tonight for our event, Having the Last Word. Our hope is that this event will teach you something about wills and advanced directives well before you need to know, well before anybody needs to know what your end of life wishes are. We have just a brief hour tonight, so I want to get right into it. But first, I want to thank Frank Delaney and the Perseverance Theater for graciously hosting tonight, or providing the platform for tonight's event and the technical support for the evening. We certainly don't have this expertise, and we're so grateful that they do and that they've provided it to us for tonight's event. I also want to acknowledge Virginia Palmer, our foundation's most recent Person of the Year. It was her inspiration and wisdom that led to the publication of our book, When You're Not There. And this book is our most important effort to help people be able to have the last word. The second edition will be provided free to those who registered and shared their mailing address with us. And I think we've already sent out about 30 of them, and we'll be sending out more as we get after the event's over with. Tonight's program is going to include 2 presentations by attorneys, followed by a brief question and answer session. If you'd like to ask a question at any time during the evening, just write it in the chat box. And if you don't know how to do that, alternatively, you could text the question to 907-321-0860, and that number is in the chat box. After the event's over, we will be posting a recording of this on our website. The question, you can post the questions whatever you want, but the questions are only going to be answered at the last 20 minutes of our presentation tonight. So I'm going to start off with Vance Sanders. Vance Sanders has been practicing law in Juneau since 1984. A lot of people know him, and he's certainly a well-liked person. Those who know him know Vance has elder law as one of his most important parts of his practice. And so at this point, I want to turn it over to Vance.
Hal, can you see me?
No, I don't see you.
Hold on just one. I'm still having technical. I'm going to log back on for something.
I could see you, Vance.
You
You
know,
can, Liz?
Yeah, I think you're just out of Hal's screen. Yeah.
Okay. All right. So thanks everybody for attending tonight. This is, I really appreciate the invite. It's turned into a beautiful night. So I appreciate you spending your time here. And I wanted to talk a bit about advanced healthcare directives. I think those are incredibly important for folks to have current directives. They're different than powers of attorney, and I want to explain the difference and why it's really important to have an advanced directive. Powers of attorney deal with things other than healthcare. Advanced directives deal only with healthcare, and that's a really important distinction. And over the years, there's been some pretty serious statutory revisions. I know when Bruce Wyrock was in the legislature, he was really responsible for a lot of reforms and a lot of changes in this area of the law, and it's been really helpful. And I'm going to try to share here an advanced directive and go over with folks what, let me see if I can load this, what I'm talking about. Let me know if you can see this. Can everyone see this document?
Not yet.
I don't see it.
What's that?
I do not see it.
Okay, hold on. Hal, do you guys have a link? I know Frank was asked about maybe we could link this. Is that possible to have that linked and show that one that was that I emailed?
I don't, that would be a question for Frank. I don't know the answer to that.
Okay. Well, if not, if you can't see it, I'll just go through it anyway, just so that folks are.
Did you put it on share screen?
Yeah, I did. I'm just having some problems here. I don't know what is going on with my, let me try that to put it on share. I had it on there before. Give me a second. It's just not, that icon is not responding.
The host might need to give you permission to share screen if you haven't been given that permission already.
Yeah, I'm clicking on the icon and it's not responding.
Who's the host?
What's
So
that?
you have the document open on your side, on your computer.
Yes, it is.
And when you click on share screen, you go to that document in the screen that pops up, and then you'll have to click share at the bottom.
Okay, that's what I've been trying to do. I've got the document loaded and I'm clicking share and it's just not responding.
Vance, this is Liz. Do you mind if I try?
Sure, go ahead.
Is that up?
Yes. Yes.
So you can see it now?
Yes.
All right. Yeah, I'm sorry, guys. I don't know what's going on my end here. I apologize for the technical.
It's very small print.
Okay, Liz, can you enlarge it at all?
Each user can zoom in.
What's that? Can you guys see the document that Liz is sharing?
Yeah.
Yes.
Yes.
Okay, I'm just going to start then talking about that document. Hope folks can scroll along and follow. The first part of the form deals with its basic explanation about what you're doing when you sign the document, about what its purpose is, about how it works and how it's to be honored. What's that? And how it's to be honored by healthcare professionals. So if you, Liz, can you scroll down to the first part there that says the durable power of attorney for healthcare decisions, part 1?
There.
Okay, thank you. So this is the really important part, is where you designate the agent or the person you want to make these important healthcare decisions for you. And you identify that person, you include his or her name, address, and telephone number. Folks that can't serve in this capacity, if you're like in an assisted living home and an employee of the assisted living home or nursing home or some other healthcare facility, unless they're a relative, they cannot serve pursuant to Alaska statute as your agent, your designated agent. So my first advice to folks is the agent that you speak with, that you appoint as your agent, you definitely should talk to that person before you designate him or her, because this is a really important role that a person serves. A person has an incredible ability to affect major decisions about your health care. So you need to make sure that whoever that person is appointed, your agent, that he or she's trusted, that they understand what you want to happen. You're very clear with that person about what your, what your expectations are. If something happens to you, you're not able to make those decisions for yourself. So that's the first thing. You can designate, even though the form only has a single agent, I have designated co-agents before if that's what a client wants to do. So that's possible. You just change the word individual to individuals. And you'll see on the form that there are optional, that you have a successor agent, a primary agent, as it's called an alternate agent, and then a second agent if that person is either unable or unwilling to continue or to serve as your agent to make these decisions for you. On page 3, section 2, this is really important, the section that deals with an agent's authority. They are duty bound to follow your instructions and your wishes to the extent that those are known. So, and the form is not, in my view, is not very user-friendly in the sense that there's 3 lines on section 2. I have had clients, and I've advised clients to do this, is add, see additional pages and really give very detailed instructions about what you do and don't want done. I've had clients that have a history, for example, of family dementia, and they've been very clear that if there's certain markers that are reached, there's certain things that they do not want their agent to authorize for them, and they've been very clear about what that would look like.
Yeah, talking about advanced directives.
What's that? So that's a really important point, is that section 2, you really need to be very careful and give clear, concise directions about what you want. And additional pages are fine. You just say, see additional pages incorporated by reference, and that's fine. So your agent has to make decisions in your best interest, and that's defined on page 3. It means you look at the benefits resulting from treatment, whether those outweigh the burdens that you would receive from the treatment. And there's these factors that are listed on the form. Those are lifted directly from the statute, actually. So you need to read through those really carefully and make sure your agent is also aware of those factors, because those are what are going to govern the statutory best interest test when there's a decision to be made about your health care. On page 3, section 3, when an agent's authority becomes effective, I don't understand why people would not check this box. I mean, if you don't do it and you're hit by a bus or something happens to you, then your agent has no authority to make these decisions for you. And just because you check the box doesn't mean that you have to give this to everyone. Although, years ago, I gave my wife the authority to make healthcare decisions for me, and it's in a file. She knows where it is. So I just think it's important to designate the person presently and not leave that box unchecked. You also, in this document, can designate a guardian, that if you need a guardian, the courts would defer to your choice for a guardian. It's typically the same person that you list as your agent. So you'll see, moving on to page 4, there are specific instructions for healthcare. And the first one there, section 6, which is on page 4, is end of life decisions. I will say that this is not one size fits all. It's very, I have clients that make decisions here all over the map. Some people want to have their life prolonged so long as they're not in pain. Some people don't want that. They don't want food. They don't want hydration. They just, if they have a condition that's irreversible and there's no possibility of them recovering, and you see the circumstances there for the condition of permanent unconsciousness and then a terminal illness. And just like I said before, the additional instructions part of this section is really important. If there's something you feel strongly about, you need to, don't be limited by the 3 lines that are under additional instructions on section 6. You can go on as long as you want to make your wishes clear. And below that, there's artificial nutrition and hydration. Do you wish to receive it? Do you not? And other instructions, again, that's an opportunity to be, more directive or more convey more information than these lines allow you in the form. And this is just, these are very personal decisions that you make as the principal, but you want to make sure when you make them and you're clear about them that your agent has the intestinal fortitude to do what you want to have done, because it's, my experience, it's not so easy to make some of these decisions. I'm going through this right now, my family with my father, who has end-stage Parkinson's, and these are just extremely difficult decisions to make for someone, but you just have to find someone who's going to abide by your wishes. Going on to page 5, there's the relief from pain. In my experience, most people do want to have pain relief, so that's a pretty common box to check. And I don't know, Hal, if you have posted this on the website, but I will send my template, my Word template, where you can check the boxes as you go through it, just by right-clicking the boxes. And I just think it's really important for folks to make sure everybody has access to these documents in a way that works for them. Part 3, which is on page 5, has to deal with anatomical gifts at death. And again, this is just a really personal choice. In mine, I chose to give any needed organs or body parts, but that not everybody does that. I have one client who left his body to the University of Washington to be used for the medical students. So that this is your opportunity, to do whatever is important to you with your organs once you pass. Mental health treatment is often overlooked, but can be really important. And this is on page 5, moving on to 6. If you have a condition if you have a mental health issue, what do you want folks to do? Do you agree to administration of psychotropic medications or not? If you don't consent, why? Typically, what medications would you consent to if it's not psychotropic medications? And understand that this can be really important to convey, but ultimately, if there's a serious mental illness and there's a hospitalization, this would not override a physician's determination about what is in your best interest and to meet your situation in the moment. There's a section on electroconvulsive treatment, admission and retention to a facility. How long do you do you agree to stay in a facility? It can't exceed 17 days. But unless there's a court order that authorizes an extension and what's called an involuntary commitment order, that would override this again. But it's important. A lot of people just kind of look at this and go, oh, this is not going to apply to me. Well, that's not necessarily true. You have certain physical conditions. For example, I'll go back to my dad with Parkinson's. There's a mental health component to that. As it advances, many times folks have dementia. What's called Lewy body dementia is a very common part of Parkinson's, and you hallucinate, or the folks do typically hallucinate. There can be all sorts of mental health treatment considerations that have to be, thought about and dealt with. The next section, part 5, your primary physician. It says optional. I think it's just really important to list who your primary physician is by name, address, and telephone number. That way, if there's, for example, if you're medevaced or you're in Seattle for treatment, then the person who's looking at this form has access and knows exactly who to contact to get information about your healthcare physician or your healthcare information. And then you've also got, if it's not your treating physician, you've got what's called a primary physician, excuse me, that you can designate. And you need to date and print your name and date and sign. This is on page 7. You can sign in front of a witness who's not related to you, although my experience with healthcare professionals is the more formal this document looks, the more it's given credence. That may, doctors may tell you something different, but I've had a lot of experience over the years with if it's a family member or someone else who witnesses this, or not a family member because they're not supposed to witness it, but if it's someone that's not known to the healthcare provider and it doesn't look formal, that can raise some real red flags. So I always recommend notarization because you have the seal there, you have a notary. It's clear that to anyone to whom this is presented, that at least from the notary's perspective, you had capacity to understand the form and to fill it out, and to at least at the moment at which your signature was witnessed, they knew who you were and that you understood what you were doing. So that's always my recommendation, is to have it more formal rather than less. So. And so that's a somewhat quick version of how this works, but I can't emphasize enough how important this document is, and particularly with a power of attorney and the will that Liz is going to talk more about. But this is a really important document to have an arrow in your quiver. So with that, I'll leave it. I'll turn to Liz. And Liz, thanks for being able to share this.
My pleasure.
Well, I'll introduce our second speaker is Attorney Liz Smith. Her office is downtown. She's just up the street from me. And she describes herself as an attorney and a life coach and seeks to guide clients through the estate planning process. She's been an attorney in Alaska for 10 years, but she opened her own practice here just 2 years ago. So Liz, I'll turn it over to you.
All right, thank you. And I'm going to all right. How will you give me a thumbs up? It should be this screen. Oh, now I just lost. I'm going to hope someone butt in if you don't see the presentation, but I'm just going to dive in. I know we're limited on time. And
is there on your screen? Yeah, your slides are there.
Thank you, Hal and the Foundation for End of Life Care for hosting. I'm going to talk about wills. And I'm going to actually first introduce myself a bit, which I won't add too much more to what Hal said, and then talk about assets if you die. And I'm going to do that by talking about what the state's plan is for you if you have no plan in place, because I believe that if you have an understanding of what would happen without a plan, sometimes that can help you decide to take action if you want something different to happen. We'll cover probate, which is part of the state's plan, as well as with a will, advantages of having a will. I'll talk about when you might want to talk to a lawyer and some free resources for wills, and then help guide you towards your next step. If you decide after this evening, Vance's presentation, the guidebook that you have received or will from the Foundation for End of Life Care, thinking through what to do next for you. And then we'll answer your questions. All right. So just briefly about myself, as Hal mentioned, I've been an attorney for about 10 years, was in Juneau before that. So I've lived here, or called Juneau home, since 2005, though I left for law school. And then one of my first years as an attorney was up in Barrow. And I worked for the state for most of my time as an attorney, I was a public defender and then worked for the Attorney General's office. And as I looked for the perfect job for myself, I realized that it wasn't happening with the state. And when I graduated law school, I thought, I did this, went to school to make a difference, and I didn't see private practice as the way to do that. But I wanted to start a business. And after 10 years, here I am in private practice. I do mainly estate planning and also work with some business owners. And I do feel like I get to make a difference in people's lives. I love the work I do. I started Liz Smith Law 2 years ago, and it's been amazing for me. And then my goal with a health coach background is to help individuals move through the process of estate planning and take action that you might have been putting off and might not ever get to. It's easy to do, as with our health, right? It's so easy to wait till tomorrow to start the workout plan, but someone to help guide you can make a big difference. All right, so what is a will anyway? Merriam-Webster Dictionary defines a will as a legal declaration of a person's wishes regarding the disposal of his or her property or estate after death. In some ways, I think that can be a bit misleading, because when it comes down to it, a will is what you need if you have assets that have to go through court upon your death. Now, even without entering to court, it might guide your wishes, but generally it's only really if you end up in court in a process called probate. So what is probate? Probate, I'm going to start explaining probate by talking about what would happen without a will or another document in place, and then we'll discuss what a will does to assist your family through the probate process. So for this process of probate, there is a personal representative, otherwise known as an executor, and that person's role is to work with the court. They decide if they're going to hire an attorney to help with the process. They make sure that timelines are met, that paperwork is filed, there's notices that have to go out, there's probably publishing in the newspaper. So there's a lot of things, and that personal representative plays that role. They also put together an inventory of the deceased person's assets and then figure out the distribution. They can be paid for that role, but it doesn't mean that they are going to inherit any more. It has nothing to do with inheritance, but more the work. In statute, if you don't have a plan in place, there's priority for who would serve. If you're married, that's going to be your spouse. If you have children and no spouse, then children all have equal priority. So that's where it can get complicated. If you have a number of children and maybe they would fight over who would be that role. So you can think through in your own family, if you don't have a plan in place, who might step up to serve in that role. And sometimes it's someone without what I refer to as priority. That is generally fine as long as everybody agrees who would have what they call higher priority. And timelines, probate generally takes 12 to 18 months. Sometimes it can be quicker, but it's a longer process. There's publishing that has to go out to creditors. That's part of the time frame. It's also a public process in terms of what gets filed with court. I mentioned an inventory of assets that has to be put together, what the deceased person had, and then the distribution. If there are minor children, so if you have minor children and you were to pass away or anyone dies with minor children, those assets, they can't inherit right away. And so through this court process of probate, someone will be named to manage, to hold on to assets until that child turns 18, and then they would inherit everything outright. So some people call probate a lawsuit that you settle with your own money for the benefit of creditors. In some states, probate is a nightmare that you want to avoid at all costs. In Alaska, in some it's easier. In Alaska, I think we're one of the relatively easy, but it can be a hassle. If you wanted to avoid probate, a will does not help you avoid it, but we're going to talk about what a will does do. All right. So before I talk about what a will does and why you might want it, there are mechanisms to avoid probate. So you may have assets that would not actually face that lengthier court process that I went to. went through. And so when you think about your own estate, some assets generally don't go through probate. So retirement and life insurance accounts, I'm sure you probably recall naming beneficiaries on those accounts. You can have a primary beneficiary and then a secondary beneficiary. And if you don't know who those people are, I recommend that you look, because even if you have a will, whatever you list as beneficiary, that's going to control, and those assets will go to those individuals outside of court. And then transfer on death deed is another tool in Alaska that you can use. There's some downsides, but there is a template on the court's website to prepare a transfer on death deed. What that does is it says that when I die, I want my home, my real property, to go to a specific individual. Now, I should say, if you're married, then you don't necessarily need that upon the first death, depending on how you own the your home, for example. Real property, it may just go to the spouse automatically. But I'll leave that out there, that there is a transfer on death deed. And that reminds me that I should say that while I am an attorney, I'm not your attorney unless we have a written engagement agreement. And so I'm covering extremely broad overview here to give hopefully provide some useful education and thoughts, but not specific advice to your situation. All right, and then a living trust is another tool, a fully funded living trust to avoid probate. And that's really outside the scope of these few-minute presentation, but I'd be happy to discuss more with you, and I cover a bit more. I usually do a monthly webinar that you can find at lizsmithlaw.com/events, whatever's upcoming, if you want more information on trusts, really to avoid probate. And then also in Alaska, if you meet all three of these conditions, then there's a separate process that's more streamlined. It's quicker than full probate. So that you have to meet all three. You do not own a house or other real property if the vehicles you own are worth $100,000 or less, and if the entire value of your assets is $50,000 or less, then you may avoid probate. All right, so why have a will? What are some of the benefits of it? Keeps your family out of conflict. So actually, I completely overhauled or didn't mention with the state's plan for you, if you don't have a will, is where your assets actually go. That's an important piece of the puzzle. Generally, if you're married, assets are going to go to your spouse. There is some potential, if you have children from a different relationship without your current spouse, that assets could go potentially to another child at the first death. Otherwise, assets generally go to your children, and beyond there, it gets a bit more complicated. But there are things in statutes. One important thing to note, of course, is that you will never give to charity if you don't have a will or some other mechanism to name a charity. So sometimes people just aren't thinking about that. So I like to mention that if you did want to donate. All right, so a will keeps your family out of conflict because you're deciding who you want to serve in certain roles, who you want as your personal representative, and where assets go. So sometimes family might argue over personal representative because they want the role or really don't. So it can help to have that. You have control with the will if you want your children to inherit at later than 18, if there are minor children, if you deciding where assets go, etc. It's perfect if you won't face probate, and you need name guardians for minor children through a will. I just wanted to cover some of the technical aspects of a will. Who can make a will? You must be 18 years of age or older to create a will. You must be of sound mind, and there is a technical definition, but basically it means you're able to understand what you are doing and the consequences of your actions. It's really relatively low bar. And then A will must be in writing, signed by the testator, which means the person making a will, and signed by at least 2 individuals. Now, like Vance said with the advance directive, getting notarized, I would highly recommend any will be notarized. If you are, there's something called a holographic will, which has some different rules to it that must be handwritten. So if you are just going to want something super simple in place, handwrite, don't type it up on a computer and then try and have it notarized. I'm not going to get a lot into holographic wills or do it yourself. I will provide some free resources for a template, which I would recommend more than that. One thing to think about as well is that if it's handwritten, for example, there's potential for more litigation to declare the will valid and other. For storage of a will, the court system will hold on to the will for you for safekeeping. Now, why would you want to do that? It's very, very important upon death to have the original will. So there should be one original, and it's something you're going to want at death. So I recommend for most people that you put the will at the courthouse. There's a form you fill out. It's $50, but that's good for life. You can get it out at any time if you were to move, or if you update your will, then you ask for the one back and then deposit the new will. All right, so I like to talk about whether to do, if you want to create a will or some of these other tools, whether to do it on your own or working with a lawyer. So with an attorney, you have added assurance the people you love stay out of court and out of conflict. If you want the people you love to have someone to turn to if something happens to you, that can be helpful to start developing a relationship. My grandfather passed away about a year ago at 100 years old, and my aunt had been his executor developing a relationship, and that helped her in her grief to have someone to turn to. Sometimes it's easier to hire someone if you're not getting to it. If you want to create a trust, which I didn't talk about a lot. And then I just have some other things that are more complicated. If you're an unmarried couple, blended family, unique situation. I have a link here, which is, we won't post the link in the comments, but you can just go to the court website and look up self-help and then probate. They have some great resources. A lot of that probate, of course, is after someone dies, but those can be really helpful just to get a sense of what it is, and that can help you now at planning. Legal Services has some good tools. You can just look up Alaska Legal Services. Looks like if you went to life planning, you'd probably find some good resources. And then Vance is going to send out that advance directive. Juneau Public Library, for those local, has an amazing database that is free for anybody who's a member of the library. You can talk to them. They have templates for different documents, like a will, and that is a recommended resource for you. I'm gonna go through pretty quickly some last thoughts. I'm going to skip that side and ask you to take a moment to think about if there's something you heard today that you want to take action on. And then invite you to think about what your next step is. So as I said at the beginning, my goal in the way I think about estate planning, because it's such a hard thing to put off, is what to do about it. If you are attending this evening, chances are well, I think a lot of people probably are attending just because, but there may be something, maybe you're thinking, oh, you know, what did I put on my advance directive? Or maybe you're thinking, well, there was some talk about a power of attorney. Do I have one? What's actually in my will? Am I comfortable with it? And so I invite you to think clearly, if there's something nagging at your mind, what is your next best step to take to move forward? So that might be just finding your document. That might be filling out the guide that you received from the Foundation for End-of-Life Care, or that they will be sending you if you haven't received it yet. And if that's your next step, I invite you to schedule that on your calendar right away. If your next step is to fill out that advance directive, if you don't have one, once we get done this evening, take a second, find a time and actually schedule that in so it gets done. If you want to reach out and talk with an attorney such as Vance or myself, or research other options in town or local to you, I invite you to do that. And if you're unsure about the next step for you, or would like to hear more about how we work with clients, I invite you to book a 15-minute meeting with our Client Services Director, Alexandria Weddle, and she can direct you to either free legal service. She can help you figure out your next step if you're unsure. So that might be the free legal services, or she can tell you how to get a life and legacy planning session with me for free, which is a 2-hour working meeting that she can prompt you through. So that link for us to schedule with her is bit.ly/mygiftfromLSL for Liz Smith Law, or you can just go to lizsmithlaw.com and you'll find it to book a meeting with us. And then lastly, because I know it can be easy to procrastinate, just one bonus if that's your step is to talk with us. If you book that call this evening and end up it turns out that you want to work with us, we'll give you $250 off any planning, just as our bonus to move forward. And I'll end there. Thank you.
Okay, well, thanks so much to Vance and Liz. We do have a lot of questions. I'm sure we're not going to get through all of them in 20 minutes, I'm pretty sure. But I'm going to start off. We have several questions that deal with something similar. So I'm going to turn these into one question. Some people say they had, one person had a will in another state, and some people have a will here, but they spend time in a different state. And so the question really is, how do these wills transfer back and forth among states? And so I'll turn that over to Liz.
A lot comes to mind, and so to sort through, but one thing I want to say is if you have real property, so if you owned property in multiple states, know that you're going to go through court probate in those multiple states if the home doesn't pass outside of probate. But the actual will in terms of the legality in either state is going to transfer. It might if you're back and forth, I wouldn't worry about it. You're not going to want wills in 2 states. If you move to a different state, I recommend you meet with someone in that state, have them look it over. There's different laws surrounding property in different areas.
Okay, here's one for Vance. What if someone changes his or her mind about advance directive? How do you go about updating the form or just negating what you put down before?
You can revoke it in writing. There can be a written revocation of it, or you can just create a new document that does what you want to do now.
How do you keep track of the versions there?
I'm sorry?
How would you keep track of the versions? I mean, when somebody's actually in the hospital there,
Yeah.
and question about versions, how is that dealt with?
Well, I would destroy the versions. I mean, if you have one, first of all, if you revoke something, keep the revocation, but make sure that document is no longer viable. So you can either shred it or destroy it. You want to make sure that your current wishes are reflected in, you don't want to have 4 or 5 different versions and have a healthcare provider not know which version is current or which version you prefer. Because remember, the purpose of this is to convey your wishes, but also it's to give the healthcare provider comfort that whatever they do, that they're not going to be sued, that they're not going to be liable to, Liz was talking about, to family or family members at a really difficult time. So you want to be very clear about what you want to do and give a healthcare provider cover as well.
Well, then if I'm hearing you right, you're saying it's each individual's personal responsibility to have his or her forms in order and have them accessible.
Yes. And back to Liz's point, Hal, I think it's really important when you do the will, don't think of it just as a standalone document. You want to make sure that you have that your will is current, your advance directive, and your power of attorney, that those are all, they all go hand in glove, and make sure that those 3 documents are current.
I have another question here about advance directives. It's similar to the one I asked Liz, but the question is an advance directive from another state valid in Alaska? And similarly, or something that was put together in Alaska valid in another state?
They are valid, but there are things that are statutory in our law. For example, if you had an advance directive in Oregon that has what's called a Death with Dignity Act, and that actually allows someone who wants to end his or her life, there's a procedure in Oregon that would permit that. But if you had an advance directive that referred to that, possibly, Alaska would not recognize that provision in an Oregon advance directive, because there's a specific statutory provision in Alaska that says that that's not going to be allowed. Having said that, I will say that I've been talking with a legislator who's actually, I think next session is going to propose a Death with Dignity Act, and has been very thoughtful about how that might look. But yeah, but generally, yes, due to the Constitution and the duty of one state to recognize the laws of another, it will be recognized.
Okay, here's another one, I think, for Liz. Well, you had talked about the first death, and that gave me some hope that, I mean, I personally would imagine I'll just go through one death, but maybe there'll be more than one. But can the transfer on death deed provide for 2 or more individuals to transfer the deed? And I think you were talking, in the first death, I think you were talking about the death of one spouse, weren't you?
Yes, yeah. I'm sorry. I always talk about the first to die and the second to die with the married couple.
Can the transfer on death deed be set up for 2 individuals?
Yeah, my understanding is it's just one, but actually, Vance, why don't you correct me if I'm wrong on that?
Yeah, you can, and in fact, I've done transfer on death deeds that reference the marital status and said that they own property. What Liz was referring to, it's called by tenants by the entirety, or husband and wife, or wife or husband. And in the deeds I said, it just says that the first to die, that the surviving spouse automatically takes all interest in that property. So when the last to die, when the surviving spouse, the later one to die, when that occurs, then the transfer and death deed comes into effect on the date of that death. And then the primary beneficiary is the language in that deed. That's when he or she would get title to that property, would be the later death.
Yeah, but you couldn't do Joe, and then if Joe is deceased, Jill.
No,
right? Yeah.
no.
That was my understanding. Yeah.
Yeah. Does that answer your question, Hal?
I think so.
Okay.
Here's another one about advance directives. It's similar to what we had already talked about, but the person asked the question, how do healthcare providers get my advance directive if I'm unconscious or medevaced out of town?
Well,
and it's back to this issue of, well, you have the papers laying around, how, and if the person who's being responsible for them is unconscious, well, that creates some problems.
Yeah, well, that's a great question. And I think what I would advise people to do is, once they create an advance directive, is make sure that all of their healthcare providers see it and have a copy of it, and ask that it be put in your electronic records, so that, for example, if you're medevac to Swedish or Harborview or wherever, they're going to have a record of that. And so I recommend you take it to them and say, here you go, this person has been appointed by agent. I want you to have a copy of this, so that there's no question about, if something happens to you, that you've appointed an agent, and the healthcare provider knows who that is.
Yeah, I think in my case, Valley Medical's had ours on file for years.
Yeah, same with me, Hal. Yeah, I mean, they've had mine for many, many years. Valley Medical has, so yeah.
Do advance directives cover dementia, or should one use directives specific to dementia?
If you, when you execute an advance directive, if you're competent to do that, what the law calls compos mentis, if you have the competence to do it, it will survive dementia. If you have dementia, that would, I think, foreclose typically your ability to execute an advance directive. But what I've had people do is actually in the detail, talk about what happens if they do get dementia and about what, be very, very specific about what care they do and don't want. And I recommend that folks, particularly if you have a family history of dementia, that you give a lot of thought to having detailed instructions with respect to that.
Okay. Here's a person who asks, when you mark the box 3, and we don't have that form in front of us again, but this, Vance, I think you know what I mean. When you mark box 3, is this person able to make their own decisions if they're alert and oriented, or does it automatically go to the agent?
No, you can make your own decisions, absolutely. And you can have the agent help you make them, or just continue to make them on your own as long as you're competent to do that. So absolutely, that doesn't, just because you do an advanced directive doesn't mean that robs you of the ability to make healthcare decisions for yourself. It's just another arrow in the quiver to allow someone else to either help make those decisions or make them for you if you can't make them yourself.
Okay, here's kind of a technical question. The question is, can a person be full code? And of course, that's medical jargon. Can a person be full code and still make the decision not to prolong life for the end of life? Do you want to try that, Vance? Do you want to explain what the person means by full code?
Well, I think it means that they're basically that they're in a medical emergency, and that they're, the end is typically.
I thought the person meant when you're in full code status, or as opposed to do not resuscitate, that this is a person who's not in do not resuscitate. So this is a person that would be in the hospital in a resuscitation, they would do resuscitation. But if you're in that status, can you still make a decision not to prolong life if it comes to?
I think it comes down to whether you're compos mentis. I mean, even though you're in that state, if you're aware of your surroundings and know where you are at the date and time, and you're able to make a basic decision, I think, yeah. But if that's a lot of ifs, and I think, again, you go back to the healthcare professionals, and you got to be thinking about, from their perspective, what are they going to be looking at in terms of, following your decisions when you're in that status.
Okay, here's one for Liz. Do other states have transfer of deed on death? And if so, how does that relate to us here in Alaska?
Well, I guess it would only relate to us in Alaska if you have property, or your family has property elsewhere. Some states do have transfer on death deeds. Others have something called a ladybird deed. There's lots of different rules about passing property on death. I mean, for example, in Alaska, you can only have ownership with a right of survivorship if it's a married couple. So only a married couple can pass to the other automatically. Other states, you could do that outside. I'll leave it there. I think.
Here's another one back to advanced directives. The question is, should advanced directives be on file at Bartlett Regional Hospital or with your primary care doctor? We've already covered the primary care doctors. Do you know, does Bartlett accept those? I don't.
They do. Yeah, I was going to say both, actually. You definitely. And Bartlett accepts them. Of course, your treating physician would accept them. And I do recommend that you have them in both places.
Okay. Here's another question. We are kind of running out of questions, although they're backing up that haven't been transcribed yet. How does an advanced directive differ from Comfort One?
I think Comfort One is geared more toward hospice care, that if you have, and Liz may know exactly the answer, but that's my understanding. And Comfort One is more if you have, like I said, hospice care, if you're in that condition, it's more, you want palliative care, you want that defined, and advanced directive is broader than that situation.
Okay, there are a couple more questions in the chat that haven't been transcribed. So I'm going to just ask if you would turn to the chat, and they're starting to pop up. Do you want to just read those yourself and take turns? The first one that I'm looking at here is my durable power of attorney was created before I was married. Vance, do you want to have a look at that and then see if you can answer that?
you know how I'm clicking.
Okay,
It's
so
a
let me-
Friday. I clicked on my chat box and I don't know what's going on with it. Hang on just a minute.
Approval power of attorney was created before I was married to my then partner. Should it be rewritten now that we are married and no longer live or own property stated as our address? I'm not sure exactly what that means.
So did it name the power of attorney, name the person that he or she married? The first one?
Can't tell.
Okay, well, if it names the same person, there's no need to redo it. If it's a different person and now you're married, yeah, you need to name that person. Well, if that's who you want to name, you don't have to name your spouse, but people typically do. So I think the answer is it would just depend on whether the same person was first named as second name.
The next question is you gave some examples of law overriding, such as mental health. I'm not sure exactly what that means. Are healthcare providers bound by the directive otherwise, or can they override the situation other than where the law specifically allows them? And I think you're going to probably say, well, they're bound by what says in the agreement, but I know I personally have seen cases where the person who's sick and dying hasn't been very clear, even though there's some written instructions, and there isn't a very assertive person who's taking charge there. So the question is, can somebody override what's in writing in some situations?
Well, the mental health situation is the one that I was referring to, and a treatment provider wouldn't be able to override it absent a court order. But what I was saying is a lot of times there is an overlay when there's mental health treatment, the court can get involved and often does. And if the judge enters an order that is different than what the person has provided in the advance directive, the court order would trump the advance directive. How this is a really good point that you make. And I know there can be assertive people. That's why I recommend that folks be very clear and not be limited by the 2 or 3 lines that are in an advance directive. The more detail that you put in there, the better, because if you're a healthcare provider looking at that level of detail and you have somebody in the moment saying, oh, no, that's not what dad intended, or that's not what we want to happen, too bad. I mean, when dad could communicate what dad wanted, he did, and he should do it in a detailed manner so that you foreclose the possibility of someone later on saying, no, that's not what I want for dad. I mean, so.
I've now seen, because I've been in that hospital room with the person who's potentially dying, and I've seen what that feels like to be saying, let's unplug the person. And I've imagined what that would be like for me standing there at my wife's bedside, even though we've talked about this many times and we've been very clear with each other. It's still going to be a very difficult thing to do, irrespective of what you write down on paper.
Oh, yeah.
It does take that assertive person, and it does take that resolution. I think, doesn't it? I just don't think you can get around that.
No, I think that's right. I think it can be a very difficult, emotional time. Letting people go that you love and honoring their wishes, I think it's really important. It's not easy to do, but that's why I think the more detailed your wishes are the easier on the person who has to implement those decisions. Not just in your example, you're talking about you and your wife, you in that instance, but also the healthcare providers who feel relieved that they know that they've got cover. And I keep coming back to that, but that's the day and age we live in now. Is, particularly if you have family members, siblings, or kids that don't see eye to eye on what should be happening with a parent, that's really important to have that level of detail.
We have some more questions. How do advance directives work with medevac companies? I think you've already mentioned that if it's in the paperwork, in the files, then that carries forward. But anyway, that's the question. How do advance?
I don't. Liz may know the answer to that, but I don't. I don't know if Northwest. What is the ones here? If they have access to the electronic records of the person being medevac, it might be a good idea to take those to whoever that you have. There's the insurance for medevacs now, and I think maybe just go to them and say, look, here's my advance directive. If I ever have to avail myself of your services, you should know this because things can happen en route, as you well know, that, and there's medical personnel on board. I've really frankly never thought of that, Hal, but that's a great question. And I think maybe you take it to the transport company and say, here's what I want to happen.
Of course, if you were here in Juneau and you say your physician was at Valley Medical or Southeast, I can't remember the name of the clinic there behind Foodland. If it was in your health records there and you were medevac, it would pretty much find its way, I would think, to.
Well, I would hope so, for sure.
Here's another question. What's the difference between advance directive and a living will?
Living will was it used to be in Alaska until, I don't know how long, 10 or 12 years ago, maybe. A living will and a power of attorney were in one document. And, those were just all together. And then the legislature separated those and now they're two standalone documents. So really an advance directive is the same as a living will. It just has a different name now. So, and that used to be in Alaska, the name of them was a living will.
Here's another one for you, Liz. So this person has a will that was registered in another Alaska city. So I assume that means registered with the court. And here she wants to know if I revise it, should it be, how do I deal with the copy that's in the other city?
So to get a will out of the courthouse, you need to submit they have a form and it has to be notarized. So go to the court and get the form you need. You can mail that in and decide what you want them to do with your old will. And then when you redeposit, I think that I've had a client that was able to switch courts. So if they moved to Juneau from Fairbanks, they would be able to deposit. I'm pretty sure they do it. Otherwise, you may have to redeposit with a different and repay.
Oh, and here's somebody, it's not a question, somebody made a comment that there's a national depository for advance directives. I don't know anything about that, do you?
There are. It's actually an entity out of New Jersey, and they're their national repository, or that's where they used to be. I'm assuming they're still there. And yeah, you can definitely deposit your advance directive there. And what I have been told is, if you do that, that helps to makes it much more, well, not just enforceable. That's not the right word, but it's much more efficient if you, for example, are traveling to another state, or if you have a winter home in, say, Arizona or somewhere, to have that on that national registry, I think would be the way to go. I have not put mine there, Hal. I've been told this by many clients, though, that there's the national registry that they've deposited theirs with.
We work with a program called DocuBank, which they take the documents and then give an ID card with a PIN number. So that's another why we're talking about convenient ways to get documents, something to look into.
Yeah, good idea.
We're out of all the questions that have been turned in through chat. If anybody else has another question, I'd invite you now to go to Zoom and raise your hand, and we'll see if we can let you ask your question yourself in the time remaining. Does anybody out there have a question?
Someone asked if a person was out of the country, what would happen? I'll send that to Vance. I would assume that's for advanced directives.
I don't know the answer to that. I would think, well, I would hope that they would honor the advanced directive, but I can't say that for sure. And I think it's probably a good idea to take it with you when you travel for sure to another country, because I had a situation arise. We were in Italy one year, and I got an infection. And my Italian, I speak a bit of Italian, but not enough to really communicate what I want to do. And that was a really sobering process to go through that and try to explain what you needed. And if it was a condition that was subject to an advanced directive, I think it would be much easier to at least have someone there who can interpret, say, okay, this person doesn't want this or doesn't want that. So, but I can't say for sure that would be honored in another country.
Someone asked the question, what is the website for the National Depository for Advanced Directives? And I assume you don't know that off the top of your head, or you would have mentioned it. But
I don't.
I would assume you'd have to just,
I can Google it, Hal, and send the link. I'm sure, or talk to one of my clients who I know have deposited there and get back with you and let you know.
let's see, I'm seeing some other questions pop up. Have you seen an advanced directive change how a healthcare provider treats you as a patient or your named representative? For example, if you're DNR, will they be as willing to administer other care before the recitation would be needed? And I guess I certainly haven't seen that in my relationship with my physician, but what's your experience?
Well, I think that's really physician dependent. I mean, Hal, you and I probably had the same physician at Valley Medical. And that's why I sought out Dr. Urata is I had a really clear sense from him that he was going to honor what I wanted to do. And so I don't think it really would have mattered for him because, it was he had that unique and maybe hopefully not unique, but just a gift to really root out what was going on, how you felt about different things when it came to healthcare. So I don't think it would have made any difference with him, but there may be other physicians that you don't see as often or that you don't have as good a relationship with. It may make a change. I know talking to doctors, they are very happy when they have a patient come in and they know when they check that they have an advanced directive. That's really important to them to, at least I've been told that as part of their, they just want to know that things have been taken care of for the patient. So.
It looks like somebody has posted a website now in the chat box that might be this registry. So if you were curious about that, you might just look at the very last message.
Great. Okay.
Well, we're getting close to the end. I hate to stop things when we still have some more questions, but we are getting close to the end. I guess I'll ask one more time. If somebody wants to speak up and ask a question in your own words, just raise your hand and I'll scroll through one more time to see if anybody's done that. I'm not seeing any hands. There was a hand raised earlier and I sent that person a message a couple times to just put the questions in the chat box, but now I don't see that hand raised. There's one last. Oh, apparently there is one more. So the question is, do each of you prepare these documents for clients? And if so, can we get in touch with you for these services? And then there's the question for a fee. So maybe that is a good question. Approximately, I know there's a huge range. Approximately, how much does it cost to get help with a will? Putting a will together.
Liz, you want to take a shot at that one?
Sure, you bet. So all of the work that I do in my office for estate planning is flat fee basis. And generally, as Vance said, there's the package, right? If you're doing a will with the other advanced directives, power of attorney, and my rates typically run from $1,500 to $8,500 in a range. So that gets, and you design your plan when we start together. So you know before you commit what the fee would be.
Okay, looks like there are some more messages. Oh, this just thanks us all for, there's a thank you and there's another thank you. So I would like to thank everybody for coming. Thanks so much for coming. It would have been awfully lonely here with just Liz and Vance. We already know each other, but I really want to thank Vance and Liz for their time and expertise, all the work that they did to put this together. And I especially want to thank Frank Delaney and Perseverance Theater. Here with the epidemic still going on, we would have not been able to do this without their help. And I think this worked so well. And I'm just so grateful for not just them offering to help, but for them doing such a great job, especially Frank Delaney for doing such a great job. And I hope to see you at another one of our events. I hope you'll look for us on our new website, which is the Foundation for End of Life Care, ak.org. And we will be posting a recording of this on the website sometime in the future. For those of you who haven't got your book in the mail yet, we will be sending out another 30 or so here in the next week. And if you don't get one, get a hold of us. We have a phone number and You can get a hold of me at geiger@ak.net if you don't see it, and I'll see what we can do to round one up for you. Okay, well, thanks so much. And
Thank you, Hal. Thanks, everybody.
Thank you. Yeah.
Yeah.
Great.
All right. Take care, Liz.
You too, Vance.
Okay, thanks.
Thank you, Vance and Liz, and have a good evening.
Thank you. Good evening.